So, as next, I would like to welcome warm again Donna Rone, which she will share about the mediation in Latvia, how it developed, and what are the expertise for the next years.
Thank you, the previous speakers. Thank you, Francesco, for informing us about the situation in Italy. And I will say some few words about mediation in Latvia. Most of you are from Latvia, so you know how the situation is, but we also have a large audience here from other countries, so I hope that it will be interesting for you as well. Well, in Latvia, we have specifics with mediation in the terms of terminology. We use two terms in Latvian. One is mediation as mediācija, and other is mediation as izlīgums, izlīguma vadīšana, which means that in civil cases we use this one term of mediation, and in criminal cases we use another terminology. And mediation is covered by two types of normative enactments. One are related to civil case mediation, another is related with criminal case mediation. But the goal actually is the same. The goal is to encourage the parties to talk, encourage the parties to settle their issues by way of talking, by way of negotiating, and not just waiting for the judgment from the court. Well, sometimes we need the judgment, but many times we can reach the result with our own forces. And I must say that, well, actually, in Latvia, mediation started not in civil cases, but mediation started at a normative level in criminal cases, because a long time before mediation law was adopted in civil type of cases, this settlement process well operated already in criminal cases. So I think that the State Probation Service who organizes this type of mediation must be very proud of themselves for doing that. The very mediation law was adopted in Latvia in 2014, May 22, and actually it was adopted because of European Union Directive number 2008/52 on certain aspects of mediation in civil and commercial matters. If this European Union Directive wouldn't be adopted, I truly doubt that mediation law would be adopted in Latvia so soon, because there were, people were saying, well, why do we need mediation law? And there were also researches available that actually mediation as a process is already available. Well, there are no obstacles in organizing mediation, so do that without any law. But, well, what we can see as a consequence, when the mediation law was adopted, so much more clarity arose in many issues, so much more precise terms, precise orders, precise principles, well, especially taking into account that Latvia is quite a normative country. We still look for exact answer in the law, and if it's not written in the law or regulation, that it doesn't exist at all. So this mediation law helped for mediation a lot, and well, I'm thankful for the Parliament who adopted that in the end. And sure, there were also Cabinet of Ministers regulations adopted a little bit later on August 5, year 2014. And these regulations are already amended, and these regulations provide for certification and attestation of the mediators about the procedure, how one can become a mediator. So these two normative enactments work hand in hand. And when the mediation law was adopted, there were also amendments made, significant amendments made in the civil procedure law. I'd say one of the most efficient amendments which were made in civil procedure law says that if you conclude amicable agreement within 3 years after you started the litigation, you can get half of the state fee back. So previously, it was stated that you can get half of the state fee back if you conclude amicable agreement after 1 year you started the litigation. But let's be honest. Well, normally, people start talking to each other only when they're in the court, and rarely they got to the court earlier than after 1 year after submission of documents. So these 3 years are quite a realistic term, and now the parties are actually more motivated to talk to each other and to go for mediation with the help of mediator or with their own forces or by the assistance of their lawyers who also are trained at mediation and will know what the conversations and negotiations are about. And regarding normative regulation in criminal cases, that's regulated by the criminal procedure law, which says that in certain type of cases you can conclude amicable agreement and then the criminal case can be terminated, which is also very beneficial for the persons who has their first criminal case and are young at age, and that this criminal case could spoil all their lives. So people are motivated to participate in mediation. Regarding the roots of mediation in Latvia, well, the mediation came into Latvia in the type of courses, in the form of lecturers coming from abroad in the end of 90s. When the first lecturers started to arrive and spread this information about the wonderful tool of mediation. And many NGOs were very active, also the NGOs protecting human rights in the criminal cases. And so it started getting more and more popular. And, well, Latvians are specific with that where there are two Latvians, there are three parties, like political parties. The same happened with the mediation organizations. We have a number of mediation organizations, and as soon as one group of persons complete some courses, they establish their own mediation organization. But, well, I think it's good for the mediation to just popularize the process. And, well, officially this motion started in year 2009, when the Cabinet of Ministers adopted a concept on introduction of mediation into settlement of civil disputes, civil law disputes. But as you see, that was a long way to go, and, well, there are like many ideas exchange on how to organize that in the best way. And in the end, what do we have? We have in Latvia two types of mediators. There are certified mediators, which means those are people who have passed the certified mediators examination. And there are the rest of mediators who can call themselves as mediators, but who have not got this certification. So actually the market rules whether you want to receive the service from the certified mediator or just from the mediator, and actually sometimes the quality is the same, just the difference is in the process of examination, in the supervision possibilities, because certified mediators are supervised by the mediation council, and, well, what they risk losing their certificate if they are working like contrary to the law, contrary to the ethics. Regarding the examination process of certified mediators, the first examination was held in October 2014, and out of more than 100 persons who applied for this examination, 24 persons passed this exam. And then later, the next year, 2015, October, 14 persons passed the exam. But less people applied for the exam, so we cannot say that the results were poor. No, just the less persons applied. And it is planned that this year, in September, we will have the third examination process. So if you're interested to become a certified mediator, follow the newspapers, follow Latvijas Vēstnesis, the official gazette, where the information about examination process will be published. How to prepare for mediation examination? The examination is divided into three parts. First part is like multiple choice test. You must know by heart the law, and not only by heart, you must understand the law, and you must interpret it, so the questions are directly related to the law, and the test is complicated, and that we can see from the amount of persons who fail the first part. The second part is like writing an essay. You answer two questions on mediation, related issues, and the broader you answer, the more you show your knowledge about this question, the better your result is. And the third and the crucial part of the examination is leading the role play in the capacity of mediator. And what we can see, and also working in the certification attestation commission of this examination, what we can see that many times people who are excellent in their theoretical knowledge in mediation, they fail the third part, because somehow they don't know how to cope with the parties. Sometimes they fail in the normal human communication skills. So which means that what we need to train is less train like theoretical part, but more train this communication skills, the attitude skills, like just being a nice person skills that matters in the work of mediators. And not all lawyers or not all psychologists who are like professional in their work can be like equally nice in mediation process, because that's kind of different work. Then I want to touch in few words the mediation progress in Latvia. Well, amendments were already made in the Cabinet of Ministers regulations on certification and attestation of mediators, and what happened was a significant increase of study hours which one needs to have if you want to apply for mediation examination. So if previously in the first and the second year there were just requirement for 30 hours of studies, then now there's a requirement for 100 hours of studies. So that's a lot. But well, the good thing is that there is no limitation where you should study. There are a number of courses here in Latvia, in neighboring countries, further abroad. So the information is widely available, and even this conference will give you already 8 hours. So a step forward. When the mediation examination is done, then after 5 years, the mediators should pass so-called attestation, which means that mediators is verified once again, are they still capable in working as mediators? And they have also a requirement to keep ongoing studies, and there will be more requirements on how they will be tested. Well, because, well, life can change the mediator, they can become like too self-sure about their skills, like too confident about who they are. So therefore, to keep this professionalism in the scope in the community of mediators, this attestation is a good process to be done. And also the amendments to the Cabinet of Ministers regulations introduced more clear requirements on how the mediation examination should be organized, because after the first examination was held, we received a lot of complaints from the persons who had unfortunately failed the exam. So therefore, after we read the complaints, well, not we, but after the Commission read the complaints, it was decided to amend and to more precise the law, which was like a good thing to do. And regarding slightly about perspective, so what we expect in Latvia for mediation. Already currently we see that there's a significant increase in demand for mediation in Latvia. Well, the mediators weekly receive phone calls from a number of persons interested in mediation process, so people know what mediation is, and the judges also send the parties or encourage the parties to try the mediation, to find a good mediator and try to settle the case out of court. One more thing, there are draft amendments already coming to the Parliament, and these draft amendments will be connected with sworn notaries and sworn court bailiffs. These two types of lawyers also will be allowed to be mediators if they pass certification process. Well, currently the law has stopped for a while because there are discussions on what will be the charge for the mediation. Well, the first initiative was that the charge will be up to 100 euros, but that was not acceptable for the Parliament because, well, what does it mean, up to? So each professional will then, then dictate their own rules, or there will be a fixed price. So that's why these amendments are stopped for a while. So follow the news in Latvia on mediation, and well, hopefully this will be more and more popular, and that will give good benefits for the people in litigation and before the litigation. Thank you.